So today we're going to be talking about civil litigation, and we're lucky to have Mr. Clay Campbell with us today. He's very thrilled, and he's going to kind of give us the rundown on what is civil litigation, a few other nuances, and try to help me maybe understand a little bit more about what he does here in the office and for our clients, right?
Yes.
So like this morning we were kind of talking about like, what should we do today, right? One, what is civil litigation? We were just talking about this before we came on, and I was like, you know what, I believe I know what that definition is, and sounds sad because I am an attorney and I practice litigation, but civil litigation is a very, very broad subject area, but how would you explain that?
Very broad. I typically tell it is anything in the courtroom that is not criminal and family law. I don't do either of those two areas of law. And of course, there's some other stuff that we don't do. Like I don't do med mal.
But that would be considered.
But that would be civil litigation. The folks who do med mal typically are very specialized in that area. But it includes personal injury. It includes breach of contract. It could include disputes between neighbors. I mean, there are all sorts of things that fall under the general. Construction definitely is one that falls into civil litigation. Debt collection, any form of money is the biggest thing that we use to compensate someone in civil litigation. So it could be money owed, it could be damages to property, it could be damages to a person. Yeah.
Okay. So essentially in the civil world, so not criminal,
right.
The normal world, if two people have an issue and they can't figure it out and the attorneys can't help them get it settled, then you're going to court and you're litigating, which is fighting over the details.
Right.
In court, and that's civil litigation.
Yeah, it's unfortunately for somebody who enjoys going to trial, we don't try much stuff anymore. I mean, I'd say probably 90% of my cases settle before we get to court. Or a couple months ago, I settled one the first day of trial, which is not uncommon. But yeah, I mean, we gear up to that's what the end goal is everything along the way. The process of litigation is to go to trial.
Picking your favorite practice area or a practice area that you're interested in talking about today, like how does a lawsuit get started, right? It is a lawsuit. So let's just presume for the purpose of this podcast, right, that the two parties can't come to resolution. A lawsuit has to be filed, right? In order to get to court. Maybe explain that process of how it all gets started.
Sure. So really whatever type of case it is, if it's in the civil world, it starts with a complaint. The complaint is a legal document that we file with the courthouse that tells the court who the parties are, what happened. We include a story as far as background to support everything. And then the most important part is we identify the causes of action, which are the specifics that we say the other party did wrong. And the law in North Carolina requires us to plead sufficient facts and legal bases for our claims against the other party. So we go through, and I start at the end and come backwards. So I look at what the jury is going to be asked when we go to trial. And the jury has to answer certain questions. And then I use those questions to craft what the complaint says so that what I'm alleging in the complaint satisfies everything that needs to be there to file that lawsuit and a judge not kick it out at some point along the way. So I typically start at the end and work backwards to make sure that I can get to the end.
Start at the end being the jury instructions.
Exactly.
And then take the jury instructions and create a complaint from there.
Exactly.
And the complaint, so when you say that you have to essentially notice pleading is what you're referring to on the front end, right? So the complaint has to have language, elements, certain buzzwords we might say.
Right.
And it puts the other party, the defendant, on notice as to what allegations are being made against them.
Right.
So if you and I had a dispute and you rear-ended my car, right?
Yeah.
I would plead it on this, my name is Matt. Clay ran into me on this date. His vehicle hit me on this location. He breached, and we'll get into all these sort of things, right? But it tells you at least what I'm suing you for.
What I did wrong.
Right. Other than, I don't like you and I think you owe me money because we've had conversations, but the complaint itself would include maybe what those conversations are, the details of whatever occurred between you and I, right?
Yeah.
Okay. I understood. So then causes of action. Mm-hmm. So they're like little mini trials?
Well, sort of. They get wrapped up into we have multiple theories. Mm-hmm. And so if I can pursue multiple theories against a party, that gives me more chances that I'm likely to recover against them. And it also allowed different theories of recovery, different causes of action, same thing, may provide for different types of damages. And so sometimes we have to allege additional causes of action to cover things like punitive damages or to recover attorney's fees. But those are very specific pleadings, then that's where the jury instructions come in so that I can check all those boxes. I use those as the guide for the cause of action. So like in your case, the car wreck case, that's going to be a negligence claim. So in every case of negligence, there has to be a duty. There has to have been a breach of that duty, and then there has to have been damages flowing from that duty caused by the breach. So I would allege that. In your situation, you would allege Clay had a duty to operate his car in a safe manner. He failed to do so because he was on his phone or he was texting or he was speeding or whatever the case may be. That was a breach of his duty. As a result of not paying attention to driving and not driving his car safely, he rear-ended me. And as a result, I have suffered bodily injury. My neck hurts, my back hurts, whatever the case may be. I've incurred medical bills. I wasn't able to go to work. And we include all of those facts in to say there was a duty, it was breached, and that breach caused damages. And that's how we get to the jury down the road, as long as all of the evidence proves that out.
Okay. And that's the same sort of process you would follow for any type of cause of action you would include in a complaint? Absolutely.
So be it a breach of contract or unfair and deceptive trade practices or conversion. So if I loaned you some tools and you decided you were going to keep them instead of returning them to me, that would be a cause of action for conversion. You've got my stuff and I want it back.
But they're nice. It's nice stuff. Why would I want? I don't want to give it back to you.
Well,
right?
It's mine. It's not yours. and despite the old saying, possession is not 9/10 of the law.
Right. Not in that circumstance.
Right. So we would whatever the case requires, we look at what the possible causes of action are. What the elements are for each of those causes of action, and the elements are what you see in the jury instructions. And then we make sure that we plead all of those to put the defendant on notice of what's at issue in the lawsuit.
Can a complaint have more than one cause of action?
Absolutely. It's rare that I file a complaint that does not have multiple causes of action.
Okay.
Negligence is one that a lot of times does not have multiple causes of action unless there's some heightened factors that add into it. But breach of contract almost always has something else because there are legal remedies and then what we call equitable remedies, causes of action they have different theories, but can get you to the same place. And so we want to make sure we've covered all of our bases.
And then once you've drafted this complaint, what do you do with it?
So the first thing we do is file it at the courthouse with a summons. A summons is actually what the clerk signs. It's a form that the court puts out and we supply the information, the clerk signs it. And then we deliver that to either the sheriff or a process server. Or if the rules allow in certain situations, we can use certified mail or an alternative delivery means to get it to the defendant. Because while the lawsuit got filed, it doesn't really begin until the defendant knows about it. And that requires proper service of the summons and the complaint to let the defendant know.
All right. So a process server, that's like the guy with the pizza box.
Sure.
It rolls up and opens up the pizza box and you've been served.
Yeah. My favorite example is the one who says, you've won Panthers tickets. Something like that where you've won a contest of some sort, here's your prize. Surprise, surprise, it's not the prize you wanted.
Yeah. Okay. All right. What's the typical way most people get their lawsuit served on the defendant?
These days, it's typically we use certified mail, FedEx, things like that, where we can get confirmed delivery. That typically is the easiest. Sometimes there's a backlog at the sheriff's office that can slow things down, or people know and they don't answer the door for their sheriff, or they try to evade service. But a lot of times, certified mail and FedEx doesn't trigger the alarm like a sheriff showing up on your doorstep. Right. We've had to go to the extent of hiring a private investigator who will follow somebody around in order to hand them personally a copy of it if a person is avoiding service.
Are there circumstances where the defendant can just say, I'm not hiding, just go ahead and give it to me?
Absolutely. So the defendant can accept a copy of it, or if we exchanged some type of communications before the lawsuit got filed if there's an attorney on the other side. A lot of times, especially if I'm the defendant, I will tell the other side, send it to me. I will accept service. We know what date it is going to be. I know what the due date is going to be for the answer. And that avoids all of the chasing somebody around. You know, you're not having to deal with the sheriff or anything. You just sign a piece of paper that says, I've been served.
So let's just get the show on the road.
Right.
Okay.
Right.
Because there are some people that will evade service, right?
Absolutely.
Because you don't have to open your front door.
You do not. Right. You don't have to open your mail either, technically.
So then once the defendant's been served, is there anything that happens immediately thereafter or shortly thereafter?
Yeah. So the defendant, under the rules, has 30 days of time in which to answer the complaint. Almost always, the defendant's attorney is going to ask for additional time to do so. And here in Mecklenburg County and every county in the state in which I practice, the courts will give additional time. And so I normally, just as a matter of courtesy, will informally give the same amount of time, so an additional 30 days to respond to the complaint. Every once in a while, there's a situation where there's a timing issue that something can't allow that. But that's a rarity for us to not get that extra 30 days to answer the complaint.
I know you practice in South Carolina as well as North Carolina. Is South Carolina, the rules on answering a complaint roughly the same, 30 days?
Yeah.
Okay. All right. Is there anything different about how South Carolina, meaning the requirements of a complaint in South Carolina compared to North Carolina, or is it relatively the same?
Basically the same. South Carolina has a few different specific rules about the format of the complaint or what you can do with the complaint after it's filed. So in North Carolina, you don't really stand up and read the complaint to the jury. They can see the complaint, but you're not going to read it to them. South Carolina, that's one of the rules that's a little bit different. The way the
you
complaint
actually read it down there?
You don't, but it's not prohibited.
Okay.
There's some things that people do slightly differently. The complaints in South Carolina oftentimes are a little bit more elaborate to that end. But basically the same. And as far as satisfying those elements of each cause of action and getting to the jury at the end, same requirements. You have to still check all of those boxes in order for your claim to survive.
Then after you've got service of the answer, and then the defendant ultimately files an answer, in that answer, what are they doing?
So a couple of things. They could say there's kind of two ways to go. You can go with a motion to dismiss or an answer. The motion to dismiss challenges the legal sufficiency of the complaint. So it says, I'm not a proper party, or you didn't get good service on me, or I've never been in North Carolina. You don't have jurisdiction over me. The courts of North Carolina don't have jurisdiction over me, or maybe you waited too long, so we have to deal with the statute of limitations. For a negligence, the car wreck, you have to file that lawsuit within 3 years of the date of the wreck. If you wait 3 years and a day, I would respond with a motion to dismiss based on the statute of limitations saying you didn't file your lawsuit within the proper time. So that would be within the motion to dismiss. You're challenging the lawsuit more on legal and technical grounds. It's not so much a factual issue because the complaint controls.
Okay. Yeah, let's say the motion to dismiss is not pertinent. Right?
Okay.
It's not available to the defendant. So they're just filing this answer. What are they doing?
So in the answer, the defendant is going to say basically agree or disagree with whatever we've put in the complaint. So they're going to say, yes, that's my name. Yes, that's my address. Yes, I was driving the car on that date. But no, I did not run into you. It's because you're an idiot and stopped short and caused the wreck yourself. It wasn't that I ran into you from behind. They're going to admit or deny what we've put in the complaint, paragraph by paragraph.
So they can agree that a car accident happened, but they can disagree that they caused it.
Absolutely.
Okay.
Absolutely.
And that's the purpose of the answer.
Yes.
So it's literally just responding to the allegations in the complaint filed by me.
Absolutely.
And then after that, there's a ton of stuff that is, then you're off to the races, right? And we can do many different podcasts on all the things that happened after that. Maybe we will. Discovery, and you already hit on the motion to dismiss and all that sort of stuff. But on the front end of getting a lawsuit started, like actually getting the wheels going, getting that complaint drafted, filed, served, and then allowing the other party to respond by filing an answer. And that's the gist.
That is. That's basically what you have to do to get the lawsuit going.
I really appreciate you explaining that to me and to everyone that's watching this right now. I can only imagine that you get a lot of questions, maybe not so much about that in a consult, but as you're drafting it, because I presume that everything you draft, you're showing to the client, right? Like, because you obviously want them to sign off on it.
Right.
So you probably have this conversation with them, maybe not in the consult, because you're getting all the details right. But after you've drafted, they probably say like, well, what is the complaint? And you're like, and then you explain like, okay, here's the process that we have to go through in order to solve the problem.
Yeah, and the biggest thing that I think people misunderstand or just don't know is the time involved. So you can't compile a complaint in 30 minutes. I mean, it's something that I sit down and I a lot of times block out hours to craft a good complaint. And then I want the client to review it. And then it has to go to the courthouse. And then we have to wait for the clerk to get it back to us and things like that. So there's a lot of time involved in just getting the process going.
The old wheels of justice, right? I always like to tell my clients that the wheels of justice are more square than they are round.
They grind along. It is not a smooth roll.
Yeah, that's right. All right. Well, that's some basic information on what is a complaint, what is the answer, how to start a civil litigation process. Hopefully this was very helpful to y'all. Clay, thanks for giving us the education.
Enjoyed it.
And we'll probably do some more stuff on civil litigation matters, such as, you've piqued my interest on the motion to dismiss, so I'd like to hear more about that.
Sounds good.